And I would like to thank all of the participants on the call tonight. I know that it's late at night and your time is valuable. So I hope that this will be a productive 1 hour for you. I would suspect that most of the folks that are on this webinar have seen or read something over the last month about employment-related issues regarding COVID-19, and I'm going to just go through some preliminary slides fairly quickly just to hit the highlights, and then I would like to spend the last half of the hour responding to questions. We have in excess of 20 questions that folks have pre-submitted, and you can also type in questions, and if we have time at the end, we will answer those as well. So why don't we get started? So the biggest piece of legislation that Congress first passed relating to the COVID-19 situation is the Families First Coronavirus Response Act. From this point forward, I'll just refer to that as Families First. And it provides for two different types of paid leave. The first one being paid sick leave. And in this situation, an employee can get up to 2 weeks of paid sick leave for 6 different categories that are listed on your screen, although really it's the first 5 that are most relevant. The 6th one, Health and Human Services, has not named any other condition that would qualify, so we're really just focusing on the first 5. With the first one, it would be a governmental quarantine order, such as, for example, if we had an order from the government that said all optometry practices would be closed, that potentially would be a triggering type order. Or that if a person has traveled to a certain location, such as New York City, then they must quarantine for 14 days, or if the health department tells somebody they must quarantine, then that would trigger, number 1, employees who are subject to a federal, state, or local quarantine order. The second one is in which a healthcare provider has instructed the employee to quarantine. And then the third one is where the person is experiencing the symptoms of the virus and is seeking medical treatment and a diagnosis. Any of those first 3 items that are triggered, the employee is entitled to be paid their regular daily rate up to a cap of $511 a day. For number 4, the person is taking care of someone who is subject to a governmental quarantine order or has been advised by a healthcare provider to quarantine, then that also triggers the 2 weeks of paid sick leave, as does number 5, the employee needs to care for a child, either a son or a daughter, whose school or place of child care or regular place of daycare is closed due to COVID-19. Again, the 6th one has not yet been, there's been no parameters established for that one. So we're really focused on the first 5. For number 4 and number 5, where an employee is taking care of somebody else due to COVID, in that situation, the person's daily rate, we take that and multiply it times 2/3. So you only get 2/3 of your average daily rate, capped at $200 a day. And what we just talked about is what we're seeing on this next screen, reasons 1, 2, and 3, where the employee, him or herself, is affected by COVID or seeking treatment or is subject to a quarantine order. That person is going to get the regular rate of pay up to $511 a day, capped over a 2-week period at $5,110. And then for reasons 4 and 5, where the employee is taking care of somebody else due to COVID, either somebody that's been subject to a quarantine order, is seeking treatment for the virus, or taking care of a child who's out of school or out of child care or daycare. In that situation, it's 2/3 of the regular daily rate, capped at $200 a day, for a maximum of $2,000 during that 2-week period. The second part of Families First, in addition to the paid sick leave, we can also get up to 12 weeks, or really an additional 10 weeks of paid FMLA. And the only thing that triggers the paid FMLA was that category number 5, where an employee is taking care of a son or daughter who is either out of school due to COVID, or their child care or daycare is not available due to COVID. For that reason only, an employee can get an additional 10 weeks. The paid FMLA states that the first 2 weeks are unpaid. However, you get the 2 weeks of paid sick leave for that 2 weeks, and then you get the additional 10 weeks. And again, it's capped at 2/3 of the employee's daily rate, and you can get a maximum of an additional $10,000, or combined with the 2 weeks of paid sick leave, $12,000 altogether. Who's covered? Well, pretty much any employer that has less than 500 employees, so from 1 to 499. Employers that have less than 50 employees may qualify for an exemption. The government hasn't given us a lot of information about that, but there are exemptions that can apply, and there's documentation that you would need to be able to prove that providing the paid leave for the say for an employee's son or daughter whose school or place of child care is closed due to COVID. That is the exemption you can take. For the paid sick leave, you still are obligated to pay that. It's just for the portion that relates to a son or daughter being out of school or child care that you may be able to qualify for the under 50 exemption. The thing that does apply to the folks on this video conference, though, is there is an exclusion from coverage for both the paid sick leave and the paid FMLA for employees of healthcare providers and emergency responders. And unlike the typical or traditional FMLA that's unpaid, where it defines healthcare provider very narrowly, essentially we're dealing with physicians and mid-level providers, mostly folks that can write prescriptions. The definition under Families First basically says any employee of a healthcare provider. So that would theoretically include receptionists and even janitors at doctor's offices. And so anybody at an optometrist office would also fall within that exclusion. It's not automatic. The practice actually has to designate that person as being excluded under the healthcare exclusion. And you don't have to exclude people, so it's 100% the practice's decision and discretion. The good part about the Families First is that for all money you pay in terms of paid sick leave under the Families First, the 2 weeks, and any money that's paid under the paid FMLA, the additional 10 weeks, you can get dollar for dollar reimbursement in the form of tax credits. And so that's the carrot to have employers try to keep people on the payroll, so that they are and allow people to get paid sick leave and paid FMLA. make sure that you have this poster that I'm showing you now posted at your place of business, wherever you keep your other employment related posters. It is a requirement that this be posted. Okay, the next piece of legislation that I wanted to talk about is the CARES Act. And this is the one, and there are a lot of provisions under CARES. The primary one I want to focus on tonight is the one that I'm sure most of the folks on this video conference have heard about, and that's the Paycheck Protection Program, the PPP. And Congress designated $349 billion, and that money is pretty much spoken for in terms of the loans that have been made. However, we believe Congress is in the process of allocating more money. The number I've heard is $250 billion. So I would continue to get the applications in there if you have not applied, and try to get one of these PPP loans, because if you do it right, a good portion, if not all of the loan, can be forgiven. And if you do get to forgive it, then that's free money. So who's eligible for a PPP loan? Again, we're talking about companies that have less than 500 employees. And there are other exceptions that that do not apply to this group. So essentially, everybody that's on this video conference should be at least eligible for a potential PPP loan. So how much can you borrow? Well, basically you take your average monthly payroll, and you go back over a 12-month period, take all of your payroll, divide it by 12 to get the average, and then you can get 2.5 times that average monthly payroll as your PPP loan. And I think it's important to distinguish. We're really talking about two different things. It's easy to get the loan. The second part that makes the loan so appealing, though, is that there is a loan forgiveness part of it. And so we'll talk about the loan forgiveness in a little bit, but there is a distinction between applying and getting the loan versus the loan forgiveness. What's included in payroll? Well, we got salary, wages, commissions, bonuses, tips, PTO, any type of paid leave. Those things are typically things that are included in there. And the unique thing about the CARES Act is that it actually also provides relief for independent contractors and sole proprietors. And so that is something that's a little bit unusual that we typically don't see in a lot of the various employment laws that we have to deal with. So, and we have some questions that relate to that, and we'll get to those later. The last bullet down there, application verifications are the employer's responsibility. This is very important because the government is going to be looking to make sure that folks are being legitimate about the PPP loans. And if for some reason your documentation is insufficient, then you could be subjected to investigation by the federal government and even potential criminal prosecution if you don't have the documentation that would verify that you're entitled to not only the loan but the forgiveness portion that we'll talk about in just a moment. So once you apply and are told that you're going to get the loan, the lender, the bank, has to make the loan disbursement within 10 days of that approval. Once you receive the money, that starts an 8-week clock. And that's your 8-week period to use the PPP loan funds. And you can use those funds for the payroll cost, for interest on a covered mortgage on real estate or real or personal property, covered rent, utilities such as gas, electricity, water, transportation, internet, telephone, and also on mortgages, other rent and all the mortgages, rent, and utilities. All these payments that are being made must be on arrangements that were in place prior to February 15th, 2020. So it cannot be for new mortgages or new rent agreements that you've entered into since February 15. It must be for existing as of February 15 arrangements. The other thing about a PPP loan is that while you can pay for mortgages and lease or rental payments and utilities, you can only pay for up to 25% of your loan for those non-payroll type expenses. Now, you can certainly use the loan for more than that, but for the loan to be forgiven, you can only use up to 25%. The other thing that you need to understand about the forgiveness portion is that the government's going to look at the full-time equivalent of employees that you had essentially from February 15, 2019 through say June 30th, 2019, and compare that with that same time period in 2020. And if your numbers have dropped in 2020, then you're not going to be able to get full loan forgiveness. It will be reduced essentially by the amount, the difference. And I'll give you a quick example. Let's assume that an employer has reduced their staff or the wages between 2020, February 15, 2020 and April 26, 2020. In that situation, the amount of loan forgiveness will not be reduced if the borrower, well, for it to be forgiven, you must eliminate that reduction prior to June 30th. So in other words, you must rehire folks to get your numbers back up, or you must increase the wages if you reduce their wages below 75% of what they previously were earning to be able to get the full forgiveness. So here's the example. Let's say a business borrows $120,000. They use 20 of that for utility and rent costs, which leaves $100,000 to be paid for payroll costs. The business has 10 employees on the payroll right now, but let's assume that last year at this time, they had 15 employees. So they have 5 less employees. And let's assume the employer does not restore those 5 employees prior to June 30th, and that no employee receives less than 75% of his regular paid wage during this time period. In that situation, you can do the math and see that we have 1/3 less of employees earning the compensation, which equates out of $100,000 is $33,000. So in this situation, $33,333 would be the amount of the loan that's not forgiven. Now, you still have the loan and you still have a ridiculously low interest rate. The interest is over a 2-year period at 1% with payments starting 6 months after loan proceeds were received. So, it's still a great deal, even if you don't get it forgiven. But this calculation shows you exactly how it would work if your payroll drops in terms of full-time equivalents, or if you had individuals who are dropped below 75% of their compensation, the payroll expense for the same time period the preceding year. This slide indicates that forgiveness is not automatic. you've got to apply for the forgiveness, and you have the burden of establishing that you're entitled to forgiveness. So what does that mean? You've got to have some documentation. What kind of documentation? Well, we're not 100% certain, because while the government's come out with the law, they didn't give us a ton of guidance, and right now we're not exactly sure. We do expect additional guidance from the Small Business Association Administration to come out, but right now all we can tell you is we know it's going to be payroll records, bank account statements, canceled checks. You're going to want to be able to establish your numbers of employees and your payroll for the two comparing periods of time, so that you can show, yes, we are entitled to the full forgiveness or some percentage of the forgiveness. And if you don't have the documentation to prove it, you're not going to get any of the forgiveness. So that leads us to a lot of the questions that have been submitted, and I'm going to have Jen read the questions, and then I'll respond to them.
Great, thank you so much, Ken. And during your discussion, we did have 3 questions get typed in from our participants. Would you like to address those first or near the end?
We can do those at the end.
Okay, wonderful. So we'll get started with the questions that were pre-submitted. The first question is, it states that the PPP loan is forgivable if we pay per employee at least 75% of loan proceeds compared to previous hours from the 2 timelines listed in the CARES Act. Since we are not in office, we are looking at paying them at 75 to 80% of normal hours to assure that they are forgivable. Assuming we do that, that is still technically a reduction in hours due to coronavirus. Would the employees be able to still file for unemployment due to reduction in hours in NC?
The very quick and easy answer to that question is yes. The employees can file if their compensation is reduced by 75, well, to only 75% or 80% of what they typically were making. In North Carolina, and this is traditional unemployment, if an employee's hours are cut by 50%, or if their compensation is reduced by over 15%, then they can, and they leave employment, they can file for unemployment and are able to get it usually. In this situation, they don't have to leave employment to be entitled to the unemployment. However, let me go ahead and give a huge qualification here. I think it is a mistake for any employer to tell an employee that they're going to get unemployment, how much they're going to get, and for how long they're going to receive it. The government is still trying to get its arms around everything, and we have an interaction between the state and federal government, and frankly, North Carolina is a little bit behind the curve as it goes. It has one of the lower maximum weekly payments of any state, and it is frankly overwhelmed at this moment. And we know a decade ago, when we had the financial crisis, unemployment got extended multiple times. Some employees ended up getting unemployment for over 2 years. We do not anticipate that's going to happen this time, but it very well could get extended, but we don't need to represent that. And I can also tell you that we have seen, I've seen one employee that got laid off, and the employee said it was due to COVID. The employer, when they got the communication from DES, agreed that they got laid off due to COVID, and the employee still got denied. Now, we have no clue why that occurred. The employee is having to appeal that decision, just like any other unemployment matter where a party does not agree, and it will have to go to a hearing. But that because of something like that, I can tell you another situation where an employee who was making a very good wage, but this was their second career, they went and applied and they were eligible, and they were told that they would have gotten over $900 with the federal money kicked in. However, due to the fact that the person's getting a pension, they're only going to get $79 a week. So it's a mistake to tell somebody what they're going to receive. I mean, I think a lot of people think they're going to get the maximum in North Carolina of $350 a week, and then you add the $600 from the feds, for $950. But that may or may not be the case, and frankly, what the government does and is still somewhat of a mystery, and try getting through to DES is almost a miracle if it's between regular business hours. So my response there is the person can apply, certainly. More likely than not, they will get approved for some partial unemployment, but I would not tell them what they're going to get or make any representations about what they're going to get. And the other thing I will mention, even though it's not asked for in this question, is the person is wise here to pay them over the 75% figure. In other words, not dropping the person more than 25%. Because if you drop somebody below 25% of what they were making, then you're certainly going to not have loan forgiveness. So even though the person's not working, it's better to pay them at 75% of what they were making, as opposed to not paying them at all, because they're out just getting unemployment and zero compensation. Then that's going to count against you for loan forgiveness purposes. So we'll go to the next question now.
And Ken, before we move to the next question, we did have one comment come in related to the previous question. How about if you have staff that started on maternity leave during the same time period?
Okay. For an employee that started on, they're out for no reason due to COVID, even though they may have been out, had they not been on maternity leave, it's going to be the same rules are going to apply, because I'm assuming that we're talking about an employer that has less than 50 employees. Most optometry practices have less than 50, so you're not traditionally subject to FMLA. And so unless that person is getting some type of paid leave, which does count, and I'm not talking about the Families First leave, because the Families First paid leave does not count towards the payroll part of loan forgiveness. The PPP cannot pay for the paid sick leave or the paid FMLA under Families First. So if you were paying the person with traditional sick leave or traditional PTO that the employer has, then that would count towards the payroll cost and keeping that person as being bona fide towards the loan forgiveness portion. But if that person is out on unpaid maternity leave, then unfortunately that's one of the things that has slipped through the cracks, and that person very well may count against you. Now, there is additional guidance coming out from the SBA, and some of these very issues that we'll probably talk about tonight very well may be covered. And I can tell you in Families First, within a 2.5 week period, there were 4 different sets of guidance that the Department of Labor came out with. And sometimes it seemed like the guidance contradicted each other. And there were times that we took one set of guidance and advised clients and then got a later set, and we had to turn around and say, well, it looks like the government has reversed course, and now they're looking at this situation a different way. So I can tell you that there's more to come on that question, but right now our interpretation would be that that person would count against you for loan forgiveness purposes. Okay.
Wonderful. So thank you very much, Ken, for answering that first question. I know some of you are also typing in questions as we go. we'll get through the questions that were submitted first, and then we'll try to get to the rest of these questions near the end if time allows. So the second question is, as an employed optometrist, can your employer take all of your PTO previously earned and to be earned this year to fund continuing payment of doctor salaries, even though they continue working from home, talking with patients, answering emails, going in and seeing patients who have urgent needs, participating in live training, webinars about new EMR systems, among many other duties, including getting company emails even on weekends that they are expected to read and be prepared to respond to appropriately?
Okay, first of all, this is a very good question, but I need more details really to make sure I understand exactly where the person's coming from. So I'm going to tackle it from both sides. First of all, can an employer take all of your PTO previously earned and to be earned this year? Well, first of all, PTO or vacation is governed by whatever policy the employer has. And if the employer does not have a policy that allows it to or requires an employee to forfeit PTO, then it may be problematic if the employer is trying to pull back PTO, particularly if it's already been earned. If it's earned and there's no forfeiture provision in the employer's policy, the employer really cannot pull that back. And that's something that the employee is entitled to take. However, if the employer's policy is more broad and gives the employer much more latitude, then very well may be that the employer can take the action that's talked about here. I can also tell you that an employer can change a policy prospectively. They're not supposed to do so retroactively, but they can notify the employees in writing. They're supposed to give them at least 24 hours advance notice, and then they can change the policy. And we have some employers who are suspending their PTO policies during the pandemic, and then they're going to pick back up once they're through the pandemic, but they're doing so in writing and they're notifying the employees of these changes. But there are some employers whose policies, frankly, were not well written, and the employee has all the power, and the employer's hands are somewhat tied. So this question really depends, the first part anyway, depends upon how well the practice's PTO policy is written. Now, the other thing I note in here is where it talks about, even though they continue working from home, talking with patients, answering emails, going in and seeing patients who have urgent needs, and responding to emails, that is actual work. And people are entitled to be paid if they're working. So if this question is from the standpoint of an employee, then that employee that's doing that is entitled to be compensated for undertaking these activities. And so if the person is a non-exempt employee that gets paid on an hourly basis, then they're entitled to be paid based on the time that they're putting in. If the person is an exempt employee, then this would basically require them to be paid for their entire day's worth of salary for this particular day that they're doing this type of work. So there's a lot of issues that are tied up here, and this might be a question that's better answered on a one-on-one basis, but certainly there's some issues that are going on. Let's see if I can advance to the next. Yeah, it looks like it's there we go. And I'll read this one. how are the unemployment rules different for regular employees and 1099 employees? Let me just make a quick statement to clear up. I love the question because I can help people understand something right now. There is no such thing as a 1099 employee. Okay? You have workers. Workers are either employees or independent contractors. There is no such thing as a 1099 employee. If someone is paid on a 1099 basis, then they are an independent contractor. And for independent contractors, the employer does not withhold taxes and that type of thing. So employees are paid on a W-2, independent contractors are paid on a 1099. Now, the interesting thing about the CARES Act is that it actually does provide for unemployment benefits, and it's called Federal Pandemic Unemployment Compensation that can provide self-employed workers and independent contractors up to 39 weeks of compensation, and the additional $600 in weekly unemployment insurance does kick in. So that is something that is provided under the CARES Act. Typically, people that get a 1099 are not eligible to apply for unemployment on a particular employer's under a particular employer's account. They can apply on their own account if they're paying their own the unemployment taxes on them as an independent contractor, but they couldn't go against practice A. But under the CARES Act, they very well may be able to do that, and they certainly can get this federal pandemic unemployment insurance. So they certainly can apply.
Which leads us into the next question. Can I apply for unemployment if my hours are cut back significantly, but I have not been let go entirely?
Okay, and we briefly mentioned this one earlier. Yes, that you can get partial unemployment even though you're still employed by the company or the practice. The more the employee makes, the less in unemployment they're going to get.
Next question is, are we to assume FTE is based on 40 hours a week? And once we receive the PPP loan and consider our first payroll, when should we alert DES they have been rehired?
That's a good question about assuming FTE is based on a 40-hour a week position, because we don't really know the answer to that, because the CARES Act does not define full-time equivalent or FTE. And under Families First, it's actually defined at 40 hours a week, which is surprising because there's a lot of employers who pay people 37.5 hours a week or 36 hours a week. And so that's somewhat different than a lot of people operate. But the bottom line is, the real question here is, once we receive the loan and consider our first payroll, should we alert DES that they have been rehired? Certainly, the answer is yes. You need to notify the employees that they're being brought back at full pay, hopefully, and that their unemployment should stop. And the challenge will be to get them back off of unemployment, though, because they very well may be getting more on unemployment than they were actually earning.
Okay. I have a sole proprietorship optometric practice. I own my office building with no mortgage or rent. I have 2 employees besides myself. During the COVID-19 mandated closure of my office, these 2 employees have already signed up for North Carolina unemployment benefits under the Division of Employment Security. Do the two employees have to come off DES benefits in order for me to apply for a payroll protection program loan? Or can I apply for salary benefits for me only, along with payments for office utilities? The employees say that they will receive more money from the DES benefits than from PPP, since DES gives them an additional $600 added to their salary benefits. Is this correct? How may I best handle this? To summarize, is the PPP loan necessarily for all employees, or can the two employees be eliminated from the loan request?
Okay, I think, and this is the point I was trying to make earlier. There's a difference between applying and loan and getting the loan versus loan forgiveness. You want to get as much as you can because you can only apply under PPP one time. So you can't come back to the well and say, oh, I got more employees now, I want to get another PPP loan. So you get one shot at this. And the two employees will be counted in for loan forgiveness purposes. So if they're not there, then that will count against you and you'll have less forgiven than you otherwise would. And so your challenge will be to get these people back to work.
So the next questions, it's two questions, but related to the same topic. Are practice owners eligible to apply for unemployment? This practice has had zero income since March 13th, and they have not been paying themselves a salary for the past month. And the tie-in with that was another question we received, which was, are there unemployment benefits available for the owner or employer of a business? The business is a professional association.
Okay. Are practice owners eligible to apply for unemployment? The answer to that will be yes, if they are treated as employees of the practice as in addition to owners. For example, are they on the payroll, or do they just get a cut of the profits and paid on a different schedule? So if the practice is paying unemployment insurance on these owners, then yes, they can apply and they can get unemployment. Are there unemployment benefits available for it's the same question. The bottom line is, prior to now or prior to COVID, did the practice pay unemployment insurance for that particular employee, that particular person? If they did, they can get unemployment. They can apply and obtain unemployment.
And Ken, we just had a question come in that I do think you might want to address. It is, does PPP require the employees to be U.S. citizens? Is there any penalty if you take out a loan and your employee is not a citizen?
PPP has not addressed that particular question. To our knowledge, doesn't mean that the SBA will not come out with guidance that does address it. But what PPP looks at is, what was your payroll for the February to June time period in 2019? They're going to compare it for that same time period, February 15, 2020 to June 30, 2020. They're going to look at it and see, how does it match up? If it's more in 2020, you can get full loan forgiveness. If it's less, there's going to be less forgiven.
The next question is sort of a two-part question. So I'll start with the first part. My understanding is that with the recent FFCRA legislation, small businesses identified as fewer than 500 employees are now required to provide up to 2 weeks of paid sick leave for employees that have been laid off due to COVID-19. If they do not have the cash or lines of credit to pay, what are the penalties? And if we're waiting for a paycheck protection plan loan, i.e. the bank has not processed the payroll protection plan application yet, is there a penalty for a delay in providing paid sick leave?
Okay, are we on the right screen? I may not be.
You need to go back one.
Okay. All right. have cash or lines of credit, what are the penalties? Well, if in fact the person truly is entitled to the paid sick leave, you're obligated to pay it, and the penalties could be that you owe the sick leave and you owe twice that amount as liquidated damages. And if the person has to get an attorney, you would be responsible for their attorney's fees as well. So in that situation, you need to come up with a way to pay it. But again, if you'll remember what I said earlier, as a medical or a healthcare provider, you can exempt these your employees from being covered by Families First, so that you do not owe the paid sick leave or the paid FMLA, and so you can avoid it in that capacity. And then the second part, though, is if we're waiting on a PPP loan, is there a penalty for delay in providing the paid sick leave? If you're going to pay the sick leave, you need to go ahead and pay it. Certainly, if somebody calls you on it and brings a legal action, after basically next week, the government is going to start enforcing the law. There's a 30-day grace period that runs out around the end of next week or beginning of the following week, and the payments would have to be made, or you're subject to all of the penalties that the government would typically provide for violations of, say, the Fair Labor Standards Act. So now we're back to the screen I was at earlier.
There you go. So regarding the Paycheck Protection Plan, and following up on the questions that you just answered, if our staff is already receiving unemployment benefits, can we wait to use those PPP funds if we eventually get them when we reopen the practice and staff return to work? Or do we have to pay the regular payroll amount immediately?
Okay. The bottom line is that, and I mentioned this one earlier, once you get the loan, once the money is dispersed into your account, that starts your 8-week period where you can use the money. And it's after that, it's after June 30th that they'll look back to see how much of that can be forgiven. So you can't hold on to it. And we had this very question come up with a business that is shut down by the governor. So they can't operate. And so they're going to have to pay people to sit at home because they're not legally allowed to come into the facility, and for them to be able to get the maximum forgiveness, they're going to have to pay people to be at home. So that is the conundrum, and particularly with the folks that are getting unemployment, then can you get them back prior to June 30th so that we can get them counted in and we not be penalized or have less loan forgiveness as a result.
And the second piece to that was, does paying staff from PPP loan funds count towards the employer's obligation from FFCRA to provide paid sick leave?
You can't use the PPP for the paid sick leave or paid FMLA.
All right, moving on to the next question. Some of my part-time staff has been able to start working from home, but with significantly reduced hours after already getting unemployment benefits. However, they have to report their pay to the NC unemployment office. One employee called me complaining that unemployment benefits covered her bills, but since her return to work from home, she's no longer eligible for unemployment. And the paycheck from the reduced hours is not enough for her monthly expenses. She's in a catch-22 and wants to keep working, but has asked me to defer her pay so that she can still get unemployment benefits. Can I withhold pay at the request of this part-time worker so that she can continue to get unemployment and pay her bills? All
right, let me stop you there. The answer is no. You cannot withhold the person's pay. The next part of that question is, can we reclassify her as a volunteer? No. Now, can you pay her a bonus or higher wage when we get back to normal? Yes, but you got to pay her for her work now. Now you can agree to pay her at minimum wage, and then she can perhaps get the remainder from unemployment, but you've got to pay her at least minimum wage for all time worked.
Okay. Moving on to the next question. All of my employees have filed for unemployment. I've received the request for separation information for each. However, I'm unable to sign into my account or portal to respond to these requests. Upon sign-in, I get an error message that states, your account has not yet been approved for access to DES services. Please contact the employer call center at 919-707-1150. I've called this number throughout the day for 2 weeks and have not yet been able to speak with anyone. Also, I've sent emails with no response. Will my employees not get their claims processed until this is resolved? Any ideas?
Well, a lot of people are having issues. I got a call from somebody today that said their employees have applied 2 and 3 weeks ago and they still haven't heard. And DES is absolutely swamped. They're getting close to 150,000 new claims a week. Just to put that in context, a decade ago when the financial crisis hit, they were getting about 100,000 a month. So this is just more than they frankly can handle. But the good news is once a person files a claim, their employer has 10 days to respond to the notice of claim. And if they don't respond, then the employees are supposed to automatically get the benefits if it's classified as due to the coronavirus.
What liability, if any, would the employer, which is an OD practice, a PA, incur as a result of an employee contracting the COVID-19 virus possibly in the workplace? Would it be advisable to have the employee sign a waiver that would relinquish the employer of any liability for such an occurrence?
There is the possibility, and we're seeing it in some of our publications that across the country from legal subscriptions we receive, that there may be lawsuits that come out of this from employees who do contract the virus at work, or who contract the virus and say that it was at work. So there is potential liability. However, I think what will happen is that that would be considered a workers' comp claim, and I think that it would get kicked out of court unless for some reason the employer was just so negligent that it would be considered gross negligence. And in that situation, the person may be able to maintain a real lawsuit in civil court, but most of the time we're having innocent exposures, and folks do have some type of PPE, and so most likely their only recourse is going to be workers' comp. Would it be advisable to have an employee sign a waiver that would relinquish the employer of any liability? Absolutely not. That wouldn't be worth the paper it was written on. I'm a pretty decent lawyer, but that's one that even I could not give you something good enough that would cover you on that one. That would not be worth even talking about.
Thank you, Ken. The next question is, the PPP loan is funded and bringing employees back initially in 2 separate teams or shifts, which will reduce hours, but they plan to pay them a normal full-time hour while under the PPP for the 8-week period. How should we handle an employee who might not come back, citing FMLA reasons? For example, they have a child at home, would be the most likely reason that was given.
Yeah, and first of all, this is a good plan because this will allow for maximum forgiveness. If an employee does not have a legitimate reason, such as they're sick or they're taking care of someone who's sick and would otherwise trigger protections, then you can demand that they come back to work. And if they're not willing to come back to work, you potentially have the right to discharge them.
Okay, moving on to the next question, and I think you may have already addressed this in one of your previous answers. Is a restart bonus prohibited under PPP loan forgiveness conditions?
No, it's not. And actually, this may be the mechanism that you do get people to come back to get off of unemployment and to get them, give them the incentive to get back into the workforce. The qualification is that PPP only forgives loans or only forgives based on compensation up to $100,000. So if an employee, if you give a bonus and it annualized would kick the person above 100,000, then that would be problematic. And that would be, during that 8-week period. So we've got to be careful that the bonuses aren't making people go over that amount, because, you can certainly do it, but it's not going to be going to help you on the loan forgiveness part.
Right, and the next question is a hazard pay bonus or wage increase prohibited under PPP loan forgiveness conditions? Some opinions I have seen indicate to not go below 75% of one's previous wages or over 125%. Is there an official guidance on this?
We do expect some more guidance to come out on this issue, but certainly you do not want to go below 75%, and you cannot go over the annualized $100,000 number. And so, but it's not prohibited. In other words, you can give hazard pay, and it actually can get paid or count for loan forgiveness purposes, as long as that wouldn't, if you extrapolate it out, equate to that person making more than $100,000, then certainly that is an appropriate option.
I think we have time for one or two more questions. Okay. So the next question is, I have furloughed most of our staff and they are drawing unemployment. Once we open back up and request staff to return to work, if someone decides not to come back to work and continue to draw unemployment, but there is work available for them, how do we handle that?
Okay, well, you may do one of those bonuses that was mentioned in the previous slide. You certainly can tell them that you're notifying DES that the job is available and they're being brought back at full pay, which hopefully will make them understand that they're likely to get cut off of unemployment. And if you can't get them back, you certainly have the right to fill their position with somebody that you can pay, and that compensation would count for the loan forgiveness.
And I believe you already answered the follow-up to the last piece of that question. That is, do we report to DES that we have full work hours again?
I certainly hope we can. Right now, we need more guidance from DES, but yeah, that's what I would certainly tell the employee, and I would certainly try to report to DES that the job is ready to go.
The next question is, at what point can you require employees to return to work if they don't want to return or say they are afraid to work in direct patient care?
We can pretty much do that when we're ready to be open and operating. Either they come back to work if we have a job for them, and if they're not willing to come back, then you certainly can replace them.
Under what circumstances can you discipline or fire an employee for refusing to come back to work?
I would give them every opportunity to come back, but certainly if you need somebody to fill a position, then we've got to get the job done. And if this person is not willing to come back in the foreseeable future, I would notify them, if you're not able to come back to work on Monday, then we're going to have to try to fill your position. And that's not any type of discrimination.
If I am paying employees with or without a PPP or EIDL loan, can I require them to come in and perform office clerical tasks other than direct patient care while we are closed to routine patient care?
Yes. You can either with or without the PPP or EIDL loan, you can require people to come in and do work that needs to get done.
And then this is the last question from our pre-submitted questions. What are the safety precautions a practice needs to institute to provide a safe working environment if we come in to see emergencies or when we are allowed to return to regular patient care?
I think that we need to have plenty of PPE available. Certainly the face masks, the gloves, the antibacterial soap or hand wash, and the wipes that are antibacterial. We need to be wiping things down after and during each visit. And in fact, I went right before most optometrists' offices closed, and I mean, they wiped everything down before it touched me. And so that's typically what you're going to need to do, is just that maximum cleanliness. And then I will say, I can read real quick these 4 questions that I got, and then we'll call it a night. How many times can an employee apply for and use the emergency paid sick leave? If you decide to allow them to do it and you do not exempt them out because you're a healthcare provider, it is for a 2-week period. So all they can get is 2 weeks. The next question, is there resource application for employees to file for paid sick leave or the FMLA for documenting our practice? You're going to, yes, you certainly have a right to get the documentation saying why they need to be out. In fact, you got to have their name and the reason that they're going to be out, the provider, either if it's a healthcare provider or the governmental entity that's keeping them out. And if it's a school that's closed, you need some evidence that the school or the daycare is closed. The third question, can you use PPP loan to bonus salaries over $90,000? Are there restrictions on bonus money used during the 8-week period? We've talked about that. You can use it, you just can't take people over $100,000. Last one, when rehiring employees using PPP who were furloughed, are we required to tell them we are less than 50 employees and exempt from FMLA child care requirements? If you're going to exempt them from the child care requirements, you need to tell them that you're using the under 50 exemption. The better exemption would be the healthcare provider exemption, which takes care of all of PPP and the paid, not PPP, the Families First, the paid sick leave and the paid FMLA. But you do need to affirmatively inform the employees that they're being exempted. And I think do we have any other write-ins that I can handle real quick?
No, I think that was it, Ken.
Okay.
And so I'll just take a moment to thank you, Ken, for tonight and attending the webinar and answering those questions. I know that we did have many questions come in both in advance and while we were hosting tonight's webinar. So Ken and I will get in touch with Adrienne about how we can handle answering the rest of those questions for your group. For those in attendance following today's webinar, you will be sent an email. It'll be sometime tomorrow. It'll include a list of articles related to the issues that Ken discussed this evening. You'll also see on your screen right now, we do have a link that will be included in that email to sign up for our COVID-19 newsletter mailing list. And in addition to that, we'll make sure that both a copy of the poster that Ken referenced is attached to the email, and we will make a recording of this webinar available. We so appreciate you taking your time this evening to join us. We hope that you're able to take some of the information you learned and apply it to your own businesses. Again, please don't hesitate to reach out to us with additional questions. I'll be sure to include Ken's contact information in the email as well. And that concludes tonight's webinar. Thank you again, and everybody take care.